Those who are present.
For now, Mr. Wage also will join us, but those present is Peter Prok and Jami Yemena. For the victims, the purported victim will be raising whether they have audience before this court. But for quorum purposes, we will be put on record Mr. Bakar for the family and Mr. Olekina
Mr. Bubakar
for the family.
For which family is it?
That is the issue that we are going to raise.
That is what we are telling you.
Your Honor, I have a number of 8 families here. I have their names.
Yes, yes. We want
Families of
The families of the victims.
the massacre, let me call it.
Maybe you take the forum so that then after that we
Your Honor,
address.
It is okay, Mr. Magono, let's be orderly. I'm addressing Mr. Bubakar.
Yes. Your Honor, there are a number of victims. They also attend.
I'll record that you are for the families of the victims.
Yes, Your Honor.
Any other issues?
we'll raise the issues later. Mr. Magia, probably the state can highlight, because the state is here, under which authority have they closed the church and also the TV station? Probably they might be telling us on the basis of that, because which is Mr. Duncan Osoro,
I'm present now.
Mr. Christopher, yes sir, defense team again, those are judging. Mr. Kai is present for the defense team.
Not very clearly. Then even Mr. Jami will be relieved.
And I've allowed the second application that we have got to the defense. That the application that you have rendered a ruling on has no prayers to close the TV stations owned by the church. Neither has any court given those powers. This is the only court, Your Honor, we are for, is factored into the ruling. We'll be glad. But in the event that the directions will be to the effect that the ruling will be pushed further, we shall take instructions from our clerk and advise or present that position to the court. We leave it to the court to give directions first, based on that perspective that we have made. That's all.
Mr. Omari and
Ensure that our client is not in custody longer than necessary. That means, therefore, that if you consider the application in its merit and dispose of it and proceed to deliver the ruling that you had intended, then we'll be glad. Your Honor, we had all intended, if you look at the file before you, you have only the Republic versus Ezekiel Odinga. No other person has sought any leave to appear before you. Why I'm saying that? Yeah, just give me 1 more minute, then the
application first.
Yes.
then go to the other issues of
Yes. Yeah. Why I'm saying that, Your Honor, is that it's my assumption that even when you will be looking at the application and the ruling, we have only two parties. We would not like our other friends to come here to pretend to address you while they do not represent anybody. Your Honor, what I'm saying that the file before you.
Please, Mr. Makolo.
Yes.
This is what I'm saying.
Yes.
Can we finish this issue of that application first?
Yes.
Before we go into any other issues.
The issue before you, Your Honor, is that we want the rule.
The render me unable to deliver the ruling now. Yes. But I do not know whether I'll be able to deliver it now or not, because I do not know what will be argued by both sides. Yes. So really it is up to you, Mr. Makolo. You're saying
Mr. Makolo,
what I'm saying is this.
like that. Tutabaki kimya tukingoja koti itoe uamuzi. And Mr. Opeta, I trust that you talked to your colleagues about the position that we were seeing.
Oh, yes.
That you addressed the court earlier. I know you addressed the court earlier this morning.
Yes.
And you stated your position, and I can confirm that I confirmed from the certificate.
Yes.
Maybe you can repeat it in the presence of our LSK president.
as I'm saying, Cliff has hired an advocate to sue LSK. Shadrach can address some of that shops. To call the narrative.
The ruling, the respondent hearing, Ezekiel Odero, who was arrested on the 27th of April this year and was presented before this court on the morning of the 28th of April, in line with Article 49(1)(f) of the Constitution of Kenya, which provides that an arrested person has the right to be brought before a court as soon as reasonably possible, but not later than 24 hours after being arrested, or if the 24 hours end outside court hours, or on a day that is not an ordinary court day, at the end of the next court day. 28th of April 2023, which is expressed to be brought under Article 49(1)(f) and G of the Constitution of Kenya, Section 123A of the CPC, Cap 75 Laws of Kenya, Persons Deprived of Liberty Act, number 23 of 2014, Section 33 of POTA, the Prevention of Terrorism Act, number 30 of 2012, and all other enabling provisions of the law, and which seeks the following orders. A, that the respondent be detained at Makupa Police Station for a period of 30 days, so as to enable the investigation team to complete investigations and submit the police file to the DPP for review. And B, that the court makes any orders that it may deem fit for the proper, fair, and effective administration of justice. The applicant, that is the state, has on the face of the application listed 14 grounds upon which the application is premised, which in phrases are as follows. I have reproduced the 14 grounds as they appear in the application, so I will not go through them. The state's motion is supported by the affidavit sworn on the 28th of April this year by number 235041, Mr. George Muriuki ASP, a senior police officer who describes as restated and expounded on the above grounds. The application proceeded by way of oral submissions, whereby the state was represented by Messrs. Ipop and Jami, both prosecution counsel, while the respondent's case was urged by Mr. Magolo, advocate. So the state submissions, through the two learned prosecution counsel, the state sought for the court's discretionary orders that the respondent be detained at Makupa Police Station in Mombasa County for a period of 30 days to allow the completion of investigations. It was the case of the applicants that the investigation to be undertaken in respect of the respondent is connected to what is currently widely referred to as the Shakahola massacre, quote unquote, at the center of which one Paul Mackenzie is widely mentioned and whose activities are suspected by the authorities to be of a criminal nature and to have led to the deaths of at least 100 people. The state submitted that the offences that the respondent is suspected to have committed and for which is being investigated include, as I've stated above, the felonies of murder, aiding suicide, abduction, radicalization, genocide, crimes against humanity, child cruelty, fraud, and money laundering, and for being accessory before and after the fact. It was further submitted that the respondent and the new live prayer check 30 days so as to enable the investigation team to complete investigations and submit the police files to the DPP for review. The grounds that have been conferred by the state as constituting compelling reasons to detain the respondent are discernible as follows: that the investigating team is undertaking investigations relating to serious crimes that the respondent is jointly and by conspiracy suspected to have committed, including but not limited to all those offences that are mentioned. Which by nature and gravity are serious and complex and constitute compelling grounds to deny bail, in their view. B, the respondent may influence or interfere with witnesses, and that constitutes a compelling reason for his detention pending investigation. C, that the fact that the Shakahola massacre, quote unquote, has received public notoriety renders the investigations into the same to be of great public interest and sufficiently compelling to warrant the detention of the respondent. Now the issue for determination is whether the three grounds above that have been presented by the state constitute compelling grounds or reasons, and subject thereto, whether there has been provided sufficient material to establish their existence. Our analysis and findings. Bail is a constitutional right. Then, the constitutional standard for denying bail to an arrested person who has been presented before court is the compelling reasons test. As properly submitted by Mr. Magolo, the burden to demonstrate that the reasons for denial of bail, that there are reasons for denial of bail, lies on the prosecution to establish the existence of those compelling reasons. That was the finding in R versus Richard Itweka Wahiti, 2016 EKLR. I'm also in agreement with Mr. Kiprop and Mr. Jami that the standard of proof required to prove that the reasons for denial of bonds meet the compelling reasons test is on a balance of probabilities. And that again is as per the holdings in Republic versus Mwema Mutia, 2017 EKLR, Republic versus Mbiti Munguti, 2020 EKLR, and Republic versus Benson Ushiri Guchue, 2019 EKLR. There is no requirement under the law that the prosecution prove the compelling reasons beyond reasonable doubt. Indeed, such a standard would be impossible to meet at this point. Reference is made to the bail and bond policy guidelines at page 19. On the above basis, it is clear that the order sought for detention of the response or of the respondent is a discretionary one. A discretionary order may be issued in a case where the court has considered the material. The challenge is posed to this court when two conflicting authorities are presented before it, but it would obviously not be the place of this court to declare or make a finding that the decision of Betty Kotai Kimeiwa is by incurium, as suggested by Mr. Jami, for not considering. I know you want me to repeat that. Mr. Jami. Of course, a challenge is posed to this court when two conflicting authorities are presented before it, but it would obviously not be in the place of this court to declare or make a finding that the decision of Betty Jemutai is by incurium, as suggested by Mr. Jami, for not considering the position that Chesoni J took on the matter in the decision of Samuel Cheriot Arap Lagat. Doing so would be stepping outside the limits of my jurisdiction and also considering that the two decisions were by courts superior to this court and courts of concurrent jurisdiction, the two courts. In my view, it is adequate that the respondent has been informed through the instant application and supporting affidavit of the reason or reasons. I repeat that, in my view, it is adequate that the respondent has been informed through the instant application and supporting affidavit the reason or reasons for his detention in line with Article 49(1)(g) of the Constitution, having been brought before this court within 24 hours and port police stations in Mombasa. I will allow the state's motion dated 28 April 2023 in the following terms. That the respondent shall be detained at Port Police Station, Mombasa, for a period of 7 days, which period shall run from the 27th of April 2023, being the date that he was arrested and placed in police custody. For avoidance of doubt, the detention period herein shall lapse on the 4th May 2023 at 0900 hours. I'll repeat that. That the respondent shall be detained at Port Police Station, Mombasa, for a period of 7 days, which period shall run from the 27th of April 2023, being the date that he was arrested and placed in police custody, and for avoidance of doubt, the detention period ordered herein shall lapse on the 4th of May 2023 at 0900 hours. I hope that is clear. B, that this matter shall be mentioned on the 4th of May at 9 in the morning for the state to appraise the court on the status of the investigation and for further orders. C, parties to be at liberty to apply for any other appropriate, relevant and or desired orders. Again, C, orders of Milton, Kabulit and 60 others, 2012 Ikeran. Then, in the case of Republic and Danford, Kabagi Wagi, Justice Matibo set out what would amount basically to what compelling reasons would be. It's a long citation, but it's a long quote. But the case is Republic versus Danford, Kabagi Wagi, 2016 Ikerara. So I will not read through it. But of importance is he has pointed out the nature of the charges, the likelihood of the accused interfering with witnesses or suppressing any evidence that may be incriminating, and orders accordingly.
I say, thank you very much. We appreciate. We don't receive such recent rulings today. I was seeking a small clarification with the last article.
You'll get a copy of the ruling, yeah? I'll print it later, you'll get copies. I will print it out copies.